We are Makilala TV, the first Filipino-American TV talk show in the New York metro area. Get to know us as we talk to the community leaders, innovators, advocates, and emerging artists who affect Filipino-American life.
My name is Rachelle Ocampo, and on behalf of my co-host Cristina Pastor, welcome to Makilala TV, the first and longest-running Philan TV talk show in the New York metro area. In this episode, we are honored to have two distinguished attorneys from the Matus Law Group join us to shed light on the importance of estate planning. My hope is that this discussion will empower you and your families to make informed decisions about your estate and financial future. Our first guest is Filipino attorney Kristine Matus, the founding attorney of the Matus Law Group, specializing in estate planning and real estate. She is a member of several bar associations, such as the Asian Pacific American Lawyers Association, and dedicated to giving back to her community through pro bono work and legal counsel to nonprofit organizations. Our second guest is Filipino attorney Crranceja-Gurski, also from the Matus Law Group, who practices both in New York and New Jersey, specializing in estate planning and probate. She is a member of various bar associations and is an active member in community service, serving in leadership roles and volunteering for various organizations. Welcome to Makilala TV, ladies. So we will be going through a lot of technical terms. So my first question, just to get us started, is what is estate planning, and when and why is it important for someone to set it up?
Well, I'll start, and thank you again for having us. We think it's just such an important topic. We appreciate your platform to be able to talk about this, and it's our passion. So we're so excited. So estate planning, it's really stressing and focusing on that last word, planning, thinking ahead, thinking of contingencies, and not just with certain items, but with your life and with your family's life. So estate planning is all about what happens if. What happens if I can't comprehend things? What happens if I can't physically do something? What happens if I die? So estate planning is all about thinking about the future and things that are happening now. And so what are your contingencies? What are the plans that we can create so we can make sure your life can go on and that your family's life can go on, maybe not as least destructive and instructive and in disruptive situations, but we want to make sure that you are thinking it through and we carry out things like your wishes and how they should be protected. That's really, in a nutshell, what I always like to say is estate planning, an emphasis on the plan, thinking ahead.
And attorney Gursky, when is it important to set this up? Like right now, I just have a family of four, 1-year-old, a 3-year-old. I'm still in my 30s. Like, when is it important for somebody to do estate planning, or should be when we retire? Walk us through this.
So I have to say, that happens now. You have a 1-year-old, you have a 4-year-old. What happens if you're no longer able to take care of those children? I mean, typically we have a spouse, but what if both of you are gone? So we really have to talk about who is going to be in charge of the people that you take care of and who's going to manage the money that you leave behind. It's so important to make sure you have those estate planning documents when you have minor children and when you have people who are, looking to you for their care and protection. You need to make sure that even if you're not around, there is care and protection to be provided to those loved ones. Even if it's an adult child with disabilities, who's going to take care of that child? Is it going to be the state? Because that's what's going to happen if you don't have a plan. Who's going to handle the money from the proceeds of your estate? Who's going to take care of the house that that child is living in if you're not around? Those are the kind of things that we talk about in our estate planning, within estate planning. And during my meetings with clients, we look at who they are taking care of, who they want to pass their assets on to, who they trust to make decisions for them. So those are the kind of things that you do at any time in your life. So is it important to have now? Absolutely. It's actually crucial to have now. No pressure, but
No question.
absolutely necessary
It is
to have.
absolutely such an overwhelming um, situation and topic. And I feel like that a lot of people are in similar situations as myself, but also like not even just for my kids, but also for my parents. Like how I'm 99.9% sure that they have not set anything up. So I'm in that sandwich generation of making sure I set up my parents and also setting up my kids. Christina.
I'm in the same way.
Oh,
Yeah.
oh, sorry.
So,
This is gonna be
I
very
was gonna say
difficult.
I'm in the same position as you, Rochelle. I'm in that
okay.
sandwich position too, where I have young kids, they're still minors, and I have an older father. And so, you're running around thinking, how am I going to protect everyone? What do I have? And what I've always said to a lot of my clients is that, now you can think, now you have options because there's nothing pressing, and you can really think through what you want to do to help them. Where it's a problem is when things are going wrong. Now your options become limited because you probably have waited, and now we can only do one thing. We can only do such and such thing. Now you have the luxury of time and options. So that's why I agree with Chris that this is really the best time to start planning, because you can think things through, and then you can make sure that it makes sense and that you're not making rash and haphazard decisions.
Mm. And
So, to go into specifics, I hear this a lot on social media and among my friends. They're saying that you shouldn't do a will because the courts will have to be involved, and you should be doing a living trust instead. What is the difference between a will and a living trust?
I'll take that on. Okay. So um, so a will is what I say, what everybody needs. A living trust is a little bit extra, but in terms of what do you need it for? But the will is really addressing assets that belong to you. Can you avoid going to the courts with the will? Absolutely, but you still need a will. Here's why: because many of the assets that we have don't necessarily get passed on to who we want to, because of the way they are. They're just the assets themselves. See, for example, a house. Think about it. You can name a beneficiary for your 401k. You can name a beneficiary for your bank account. Even there are even forms with the DMV where you can transfer your car upon your passing. But who gets your house if you pass away? That's why a will is important. Who gets, a personal injury, proceeds? Say, for example, you got into a car accident that resulted in your death. And now, somebody has the authority to be able to sue that person who caused that injury to you. That would mean that there might be some money to pass on to your loved ones, maybe your minor children, now that they lost their parent. But who's going to be able to act on your behalf after you pass away? That's what a will is for.
So you're
That's
saying, Chris, that a will is mandatory. You have to have
mandatory. It is for estate planning. That's the first thing that you should.
Okay.
All right. Now, when is it absolutely not necessary? So the will doesn't really control things that already have. Like I said, if it's already given to somebody else, like you have a beneficiary for an account, you don't need a will for that. But there are other assets that you have that a will does control. Now, you ask about a living trust. Many people hear about this. Living trusts are actually really wonderful tools. It replaces a will, but you still need a will, because a living trust can hold your assets, right? The living trust could be the owner of your bank account. The living trust could be the owner of your house, so that when the time comes and you pass away, the living trust says who it goes to, because you created that living trust and you put in your living trust who it goes to, just like a will. But the living trust doesn't go through probate, doesn't have to go to the courts. And that's why the living trust is helpful. In states where there are a lot of rules, a lot of paperwork to go through the probate process, a living trust is very helpful. And I point to the state of New York and the state of Florida for that particular for that example. It's a lengthy process. It takes time for your loved ones to be able to receive what you leave in your will if you have to probate your will in the states of New York and the states of Florida. But in a living trust, it's almost automatic. Just a little bit of tax returns to do, and you're pretty much all set. So
If I can jump in on that. So I agree with Chris 100%. We've always felt that, when we're helping families, there's several tools in our toolbox. So certain tools fit with certain circumstances in certain families. When you have a trust, number one, it's just a financial tool. And the trust can do two things. And actually, quite frankly, there are so many different types of trusts. But all of the trusts have these things in common. They're a tool. They will help you avoid probate, meaning you can mention things in your trust, who gets what, and they will get it. And number three, it's private. One of the things that I think a lot of families don't realize is that when you have a will, it becomes public after you die when you decide to probate. Once you turn it into the court, right? When you're probating, you have to go to the court, and the court gets your will. Now, anybody can read your will. When I was in law school, we would circle names in the obituary, go down to the local court and say, hey, did these people have a will? I get to read everything. I know who your kids are. I know where your property is. And sometimes they would put in a lot of sensitive information that it wasn't necessary. But if I had malintent, I could probably figure out your bank accounts. I know your date of birth, and God forbid you put your social security number in there. And that's a public document. A trust is mum. Can't see it. Nobody knows what's in there. Nobody will know who's getting what. Nobody knows if you have minor children, when are they going to inherit, who's going to be helping them, who's going to be managing their money. It's a wonderful tool. But depending on your goals and things that you want to accomplish, there's a certain trust for a certain type of person. But in the big picture, we're really big advocates of trust, because here's a great example. Say you put an asset in the trust, say a house. That's a very popular thing. How do we do that? We have to rename the asset, because a trust is a separate entity and you can name it. You can have it the Matus Family Trust. We've had people name it after their hobbies, the Wine Trust. You can name whatever you want. And now you have to update an asset to name the trust. So now if I had a house, it's like my husband and I, Stephen and Kristine, we owe a house. But now if we were to create a trust, say we want to name it the Snoopy Trust. Now we update the deed and it's called the Snoopy. The Snoopy Trust now owns our house. That's in the trust. God forbid I die on a Monday, my beneficiaries can take the house on a Tuesday. If I had a will, it's still okay, but I got to go through probate. And if you're in New York, be ready for a couple of years before your beneficiaries get the house.
No way.
That's why you want it. That's why you want it. You want to look at it, right? You don't want your kids to suffer. You don't want the person who's helping you saying, I guess I got to pay the mortgage until I figure this out. That's what's happening. People, you have to maintain the mortgages. You got to pay the taxes. And you're thinking like, but it's
even after you're gone. Even after you're gone.
Yeah. That's a great topic to go into though, Chris, about debts.
I was going to ask, what if I die? Hopefully not soon. Yeah. And I don't have a will, and my husband and I don't have a will. What's going to happen to our estate?
Chris is good with this.
Oh, that's my part. Okay. So when you pass away, right, you have an estate, as you mentioned. And typically what happens is the accounts that you have jointly with people, whether it's your spouse, your children, your grandchildren, and those accounts that already have a beneficiary, they don't have to go by what the will says, because number one, there is no will. But say you don't have any beneficiaries for certain things, or you have a house, or you have a car. All of these assets now have to go through probate, regardless of whether or not you have a will. But who's going to be in charge of your estate? The will allows you to name somebody who's going to be in charge. And that will also allows you to say that that person doesn't have to buy a special insurance policy called a bond to manage your estate. So now let's pretend your husband is like, oh dear, she has a bank account here. She has a house in the Philippines. I totally didn't know she did that. She had this before we were married. your husband would have the first right to become the administrator of your estate. And basically, the law of the state that you reside in is going to make a determination as to who receives your assets. It
Okay.
doesn't automatically go to your surviving spouse.
Oh,
It,
okay.
it depends on who is in the family and depends on the laws of the state. So, like I always say, if you don't have a will, then your
Mm-hmm.
estate plan is the state law.
Okay.
So,
Is that the law in New Jersey also? That's my
Yes.
last
same
question
thing.
for you,
Everything.
Christine.
Each state has their own set of rules of
Okay.
what happens if you die without a will. But the one thing I want to emphasize is that if you don't have a will, one way or other, certain beneficiaries will receive things beyond your control. But the paperwork and the time involved is a lot because a lot of times people don't know how to do this on their own. So they're hiring attorneys, and
Oh,
the
yeah.
time and the money you're spending because there was no will is going to always be, Chris, right? Triple the fees
triple
that
the
you would
amount.
pay if you had a plan. Because we have the
Mm-hmm.
plan, we just read it, we follow through, but we
Yeah.
don't have a plan. So now there's a lot of notices. There's a lot of things that you have to file with the court. You have to
Yeah.
make sure you have the right paperwork. There's a lot of digging. And it's very stressful because everybody's waiting and you're
Mm-hmm.
not sure what's going on. And it's really open for contests. Someone
Mm-hmm.
might step in and say, I want to be involved. Why you? Make it me.
I feel like
Now we
that
have a fight.
one of the reasons why people may be hesitant to go into estate planning or hire somebody is the price. Like
Mhm.
it's not free. So how much can somebody actually expect to pay for just basic estate planning services? Is it like
Well,
$500 or is it like $5,000? Just so we have some sort of idea of what to expect and how much we should invest versus leaving it to our loved ones to navigate.
I love that you use the word invest, Rochelle,
Mm,
because that's exactly what this whole thing. We're investing in ourselves, we're investing in our family. And when you invest in something, there is a return. So when we try to decide, well, yes, anything that's worth having, anything that's worth protecting, there is an investment. And you get the return based on your investment. Now, when we help families, one of the things that you want to make sure is that, we don't like just putting out numbers out there because when you have no concept, you might be turned off or you might not be able to understand what's the value. I always have this example of someone came from Mars and said, I want to buy a car. I want to buy a simple car. Oh, that's like 30,000. 30,000. Because when you have no concept, you have no experience, you might as well set $1 million. But then the more you see how things are, the quality you want, what you want to have. I want a car that'll get me to work. I want a car that'll protect me. I want a car with airbags. I want a car that'll have good brakes.
mhm.
I probably want to spend that or more because I'm having my family in there. So, I do think that there is something to that saying, you get what you pay for, right?
Mm.
So that is something. But when you're investing in plans like this, they are custom. There is no cookie cutter in our office. So it's very hard to say, here's the fee. But I can tell you at least a range, a
Yes.
robust, thorough, a protective plan that you would want for your family should range anywhere from 2,500 and up. Because anything less than that, Chris and I have always seen they're missing this, they're missing that. They didn't have this. Ooh, that wasn't that strong. You want strong language, you want thorough language, and you want to go to a firm, everyone. And this is for everyone who's listening who does a lot of this. As you go to your doctor, and I have issues with, if I have an issue with my heart or an issue with things, I'm not going to the podiatrist for my cardiac issue. I'm not going to the brain surgeon for my gastro. So you want to go to firms that focus and specialize in estate planning. There's a lot of attorneys who are general practitioners, divorce attorneys, personal injury attorneys, and they are good in what they do.
So
But if
the
you
Matus
see,
Law Group specializes in estate planning.
yes, that is our
Because
big focus.
so when I
Yes.
was trying to research, trying to find out two Filipino attorneys who are professionals in estate planning, there was like I hit a roadblock. I couldn't find any, and finally, another attorney referred me to you guys, and I actually went through your consultant meeting, like
Yes.
a free consulting, and just to give me an idea of how much to expect, what
Mhm.
that's included in the package, and we were so helpful. So I do encourage anyone, just do the free consultant meeting, find out what they offer. And it's not even just with the Matus group, but do your research, like what you just mentioned. I know we're up like 5 more minutes, and we have so many questions. You talked about the price range. My biggest question for myself, because we have a house, and you touched upon it a little bit earlier, what are the reasons why you shouldn't leave a gift or deed like your house with your child in your will? Like, what are the negatives for that?
Well, I'll tell you why. Oh my goodness, your child cannot own property. Are we talking about your minor child? Yes. I mean, a child technically cannot own property.
Mm-mm.
So you know the word trust, right? A trust really is a vehicle to own assets where somebody is in charge for the benefit of somebody else. And let's just take that one example where you want to leave this house to your child, but they're still a minor child. They cannot technically be on the deed of the property. You can't do that because they're still minors. What happens? There should be a trust created so that when that right time comes at the age of 18 or the 21 or 25, whatever age you want it to be, as long as they're actually adults, that's when they can have that asset. That's when that house can be transferred to their name. But without that will, saying that it is going in trust for my child until they come to a certain age, guess what happens? The court holds that property in their accounts for the benefit of that child until they turn 18. And would you really want to leave a $500,000 house to an 18-year-old? Probably not. But maybe we'll have that conversation when you and I talk about your estate.
I'm actually hearing that people are putting their houses in trust to avoid like taxes, or not avoid taxes, just to not pay taxes if they were to sell their houses. Like there's a runaround way of how to do that, to give the house to your adult children in a way to
Absolutely, Rachelle. Absolutely.
take advantage of the tax.
One of the common questions that people have is say, "Hey, Chris, I want to avoid probate. I want to avoid anything. Can I add my daughter to my deed now while I'm alive? Or can I just give my daughter the house while I'm alive?" So here are the reasons why most attorneys will say it's a bad idea. Number one, if you add someone to your deed who's not a spouse or a partner, what happens is that person's situation is now yours. If they get divorced, they get sued, they have creditor problems. Now your house is now part of that issue, and you might have now additional liens and lawsuits involved. That's number one. Number two, the other issue is that if you give a house away to your child while you're alive, pretty much you're probably giving it to them for $1. I doubt you're going to be giving it as fair market value. Then what happens? Your child gets it for, say, $1. They want to sell it. There's a huge tax issue. It's called capital gains. To avoid that, we tell people, wait till you die, put it in your will, or yes, a trust is even better. A trust has a lot of things that we could do to help if there is a tax implication. And between Chris and I, we're nerds about that. We love to see how we can lower or eliminate your tax. It's like a game for us.
I love that.
How do you feel about websites like LegalZoom?
Yes.
Well, Chris and I have always chatted about that. Again, it's another tool. I love the idea that if people are looking into it, they know that having this type of tool is important. But what's really challenging is that you don't know what you don't know. You might think you understand how these documents work, and then you don't. And I like to say we're not a litigation firm, but I'll let you know I do handle several litigation cases. All of them, Chris, I swear, are all with people who tried to do it themselves.
Yeah.
A lot of times we write the way we talk, or we're writing thinking there's a conversation in our head. 10 years later, someone picks up this one sheet of paper and it'll say, I give my 2 sons a car and he can drive it. Which car? Whose son? What? Which son's driving? Who's the he? And then the fight begins. And a lot of times we're
Um,
not just talking about a car. We're talking about big bank accounts,
mhm.
houses. So again, I really feel that these do-it-yourself places are just an opening for more problems. Invest in a professional. But I think, with time and everything, we can do anything ourselves. I can build my own house, but I don't know if I trust it. I don't know if I'd like to live in it. I don't know if I knew everything how to do. So we do that with clients. Why don't you spend the time with people who do this all the time? They'll help you with time and money.
Correct.
So that was one of my questions, like, why should we hire a professional versus doing it online for wills and estate planning? Um, how often should people think about reviewing their estate plan?
I would say that you have to review it every time something changes in your life, or at the very least, maybe systematically thinking about it every couple of years. Does it still make sense? Because your estate plan is about who you trust and who you want to, give assets to at some point, right? Does it still make sense for what if, you named your sister to be the guardian of your children if
Mhm.
something happened to you and your husband? But all of a sudden, your sister moves back to the Philippines. She's not here anymore.
Yeah.
Does it make sense to still have her as the guardian if you
So
want your children to be raised here? So
yes,
every time things change, it's a good idea to revisit it.
I totally lost track of time, and it's not like me, but I apologize. We do have to close the episode, and I want to have one last question. What is one thing that we need to do right after this episode to make sure that we start estate planning? Attorney Matus.
Number one, look at the assets you have. Start gathering them. Nothing is worse than having things all around. Nobody knows where your things are. Start gathering your assets. Start making a list. Really take inventory.
And Attorney Gurski.
Think about people who are important to you. Think about the people who can help you with your life, and include that list that Miss Mattis said also, and then speak to an estate planning attorney.
Love it. Thank you again, Attorney Kristine
Thank
Elmatis and
you.
Attorney Kristine Crranceja-Gurski for joining us at Makilala TV and the Manhattan Neighborhood Network team. Maraming salamat to all our supporters and viewers. Sa ulitin.